Thank you. Thank you, everyone, for being here today. We appreciate those of you who came out and are interested in listening to the Title IX discussion we're going to be having. My name is Harriet Hageman, and I'm Senior Litigation Counsel here at NCLA. And I have some guests, and we're going to start first by talking a little bit about what Title IX is. Today, we're going to be discussing some of the challenges associated with Title IX. Title IX was the first comprehensive federal law designed to prohibit sex discrimination against students and employees of educational institutions. And the statute is really quite short and to the point. It states that no person in the United States shall, on the basis of sex, be excluded from participation in or denied the benefits of or be subjected to discrimination under any educational program or activity receiving federal assistance. It applies to both men and women, and it requires educational institutions to maintain policies and practices and programs that do not discriminate against anyone based on sex. Males and females are expected to receive fair and equal treatment in all areas of public education: recruitment, admissions, educational programs and activities, course offerings and access, counseling, financial aid, employment assistance, facilities and housing, health and insurance benefits, marital and parental status, scholarships, sexual harassment, and athletics. Title IX, however, has been quite newsworthy for the last several years, with an enormous amount of controversy in terms of interpretation, application, and enforcement. During our panel discussion today, we're going to talk about Title IX, its intent, what impact it has had in terms of higher education, as well as the latest developments. I first want to introduce our panelists who have been kind enough to join us today to discuss this interesting topic. First, we have Jennifer Braceras, who is the Director of Independent Women's Law Center. We have Hanna Stotland, who is an admissions consultant, and she is with us via Skype today. And we have Kruckenberg, my colleague here at New Civil Liberties Alliance. Starting with Jennifer, would each of you please give a brief introduction, tell us a little bit about yourselves, and focus on the topic at hand, and namely Title IX. Jennifer?
Sure. Well, I first got interested in this issue when I was a young associate at Ropes and Gray. I was a labor and employment lawyer there. And because so many of the issues dealing with Title VII and sexual harassment under Title VII were comparable to the same issues in the education context, that department also represented a lot of school districts. So I had an opportunity to work on some Title IX cases. And actually, as a volunteer pro bono attorney, filed a brief on behalf of the Independent Women's Forum in one of the first big Title IX cases at the Supreme Court, Davis versus Monroe County, which is the case that decided that students could sue their schools for peer sexual harassment as opposed to harassment by an agent of the school district. And so we filed a brief on behalf of the school district in that case. And actually, we were gratified that Justice Kennedy cited our brief in his dissent. Unfortunately, it was the dissent. And I really think that a lot of the mess we find ourselves in today stems from that decision, and the decision to allow students to hold schools responsible for, student-on-student misbehavior. But my background after that, I've done a lot of writing on this issue over the years in the popular press. I served on the Civil Rights Commission under George W. Bush, by appointment of George W. Bush, where I focused on this issue. And as Harriet mentioned, I'm back with the Independent Women's Forum now, where I focus a lot on writing about this issue from both a policy perspective and a legal perspective.
Thank you, Jennifer. We look forward to the comments that you will be providing in more detail as we proceed. And Hanna, would you please describe your background and tell us what you do and your interest in the Title IX issues?
Sure. Hello, everyone from my college counseling office here in Chicago. And the number one reason I'm here today is that I flunked out of high school. Everything else in my career has stemmed from that. I have a GED. I eventually ended up graduating from Harvard College and Harvard Law School. And that is what brought me a career, 20 years worth of students in crisis and overcoming crisis, students coming to me with difficult admissions problems. So a lot of students who've been disciplined, who are in recovery from mental illness and or substance abuse, a lot of students who've been in criminal trouble, accused of academic misconduct. And so I've been doing this first in parallel with my legal career and for the last 11 years now, instead of a legal career, solely being a counselor. I saw all kinds, eating disorders, all kinds of ways that educations were getting derailed. And I mostly do higher education. And then in January of 2014, I got my first 2 calls from students who had been expelled for alleged sexual misconduct and expelled from college, and asked me, can I go to college somewhere else? And I said, I have no idea, let's find out. And so in the last, it's over 5 years now, I've had many dozens of clients involved with Title IX, mostly accused students who have been disciplined, some accused students who have been exonerated, a smaller number of students who have been involved in Title IX as complainants, and a very interesting handful of students who have been involved as both. One encounter led to both their feeling that they were assaulted and they were accused as part of the same encounter. So I see education's lying in pieces, and try to help students put them back together.
Okay, well, thank you, Hanna. Again, we'll have you provide some more information about some of the cases that you have been involved with, so people can understand the spectrum of the Title IX type adjudicatory proceedings. And Caleb, why don't you tell us a little bit about yourself and your interest and involvement with Title IX issues?
Sure. Well, as you mentioned, I'm a litigator here at the New Civil Liberties Alliance, and I'm sure a lot of you already know this, but NCLA is really dedicated to fighting against administrative overreach in all of its forms. We do work just across the board, and when I first started hearing about Title IX adjudication on campus, it's a really stark example of what happens with an administrative agency exercising authority that doesn't really belong to it. And we'll talk about it later with the Dear Colleague letter, but what we really see is an agency, the Department of Education, is setting a very rigid policy and a set of priorities and coercing a lot of campuses to adopt these unfair procedures. And also my background, before I came to NCLA, I was a criminal defense attorney, and I've represented a lot of people in a lot of different contexts criminally. And when I started looking at this issue, it's just horrifying to me as a defense attorney who's used to complaining about how unfair the criminal process is, to see what passes for justice and what passes for a process on college campuses. I mean, some of these students are accused of very serious things, and they are kangaroo courts. I mean, that's what Secretary DeVos described them as. And so that's really where I started focusing on this.
Wonderful, thank you. Well, Jennifer, I'm going to start with you, and I'm going to ask you some questions. And if you would please explain to us, what is Title IX and what does it have to do with campus discipline?
That is a very good question. Well, as you said at the beginning, Title IX is a very simple non-discrimination mandate that tells schools that receive federal money that if they, as a condition of receiving that federal money, they cannot discriminate on the basis of sex. The way we got to interpreting Title IX to require certain forms of disciplinary procedures goes back to the case I mentioned in my introduction, Davis versus Monroe County, where the court held that, and they tried to do this very narrowly, but the court held that in some circumstances, schools that handle complaints of sexual harassment differently based on gender are committing a form of discrimination. So In other words, if a college campus systematically ignores claims by women on campus that they are being sexually abused by fellow students, but does not ignore those claims when men bring them forward, that is a form of sex discrimination. It's a cut and dry form of sex discrimination. But what happened was, after the court essentially held that in Davis versus Monroe County, that was interpreted by schools and by activists and victims' rights organizations to say, anytime a student is sexually mistreated, the school is going to be liable if they don't come down hard to address that. And obviously, schools should be addressing misconduct of all forms, right? But the notion that teachers and administrators at public schools, which is what the Davis case dealt with, aren't concerned with student safety and protecting their pupils from misconduct was sort of absurd to begin with, right? And there are all these other state law torts and laws that parents could fall back on and utilize if there was egregious misconduct on the part of the school district. There was really no need, in my view, for them to marshal the long arm of the federal government to protect their students, but that's what happened. And so basically that case was taken, it was taken to mean, I think, something that it didn't. And as a result, you see the rise of these administrative bureaucracies on college campuses to deal with the problem. And we could talk about the Dear Colleague letter, but I actually come at it from a different perspective. I believe that the Dear Colleague letter was the result of this sort of cultural shift that took place after Davis versus Monroe County in the late 90s.
Well, tell me a little bit about the Dear Colleague letter.
So the Dear Colleague letter, I think as most people know, was an edict that came down from the Obama administration in 2011 that told schools, if you don't use certain procedures in handling these cases, you're at risk of losing your federal funding. But I believe that really universities were under a great deal of pressure already from the New York Times, from student groups, from feminist groups and victims' rights organizations to implement those types of policies anyway. And I believe that what the Dear Colleague letter did was accelerate that trend and also give universities legal cover for frankly what they were going to do anyway.
Well, we'll talk about the Dear Colleague letter and some of the other changes that the Education Department has made under this administration. But Hanna, I would like you to describe and some of the Title IX proceedings that you have been involved with. If you can just describe some of the cases and the work that you have done as an education consultant.
Sure. So if you're wondering what these cases mostly look like, they are very different from, say, in the news today, a Harvey Weinstein type of accusations, where there's an accusation of force, where there's an accusation of abuse of power, where there's an accusation of things taking place in the workplace. The vast majority of the cases that I see are occurring in the context of both the complainant and the accused are generally equal. You know, both undergrads or both grad students. Typically, they are voluntarily associating in a social setting. Typically, the disputed encounter arises from what is agreed to have been a consensual sexual encounter, at least in some respects. And then in most of my cases, there's a dispute as to particular acts within the encounter, or that consent was withdrawn at some point during the encounter. And I think one of my co-panelists referred to the procedures as amateur hour, and I think that's true. I think folks on both the left and right have a lot of well-placed critiques of the criminal justice system and how it does not do an optimal job of handling accusations of sexual violence. And that is a pretty darn, I think, a pretty darn unbiased system in terms of nobody is losing their job because they're supposed to come out in favor of one side or another, or that's not mostly how judges' employment works. And it is a system that's filled with professionals who are devoting their entire careers to training and practice in these areas. And they still get it wrong pretty frequently. This is hard stuff. Trying violent felonies is hard stuff. And people who are terrific math professors and terrific deans of business colleges and so on, there's no reason to expect them to have expertise in this area, even if they go to a weekend seminar or even a 2-week training to learn how to adjudicate these matters. It shouldn't be surprising that people who are devoting their careers to some other type of expertise are not as good at this as the still flawed and human people who do it full time for a living. And so that's what you get. You get this kind of part-time, mostly pre-amateurish facsimile of, it's sort of like a civil proceeding, but not really, even though it's fairly criminal sounding acts usually that are being accused. And just as an example, maybe the most egregious example, well, a couple things. One is that the parties are permitted to have lawyers or other advocates at the hearing if there is a hearing, but those advocates can't speak. So you have 18, 19, 20-year-olds conducting these matters really without adult, much less expert guidance. And also, in many cases where the accused is going to see the evidence against him, that means you send this 18 or 19-year-old kid into a room with the record. He's not allowed to take any pictures, make copies, or take notes. And then after an hour or two with looking at the record himself, he can go and report to his parents or advocates what the evidence against him was. And I think most lawyers would be absolutely appalled that that constitutes seeing the evidence against you. So there's a lot of problems with that in the process.
Well, would you
and one other interesting observation, so I see very frequently same-sex accusations, which I see them at roughly what I expect to be more or less the same rate that that sexual encounters take place between same-sex parties. And so that's theoretically interesting to me as a lawyer, that how are you being discriminated against on the basis of your sex if you, a man, have non-consensual encounter with another man? Is your gender really what's at stake there in the imposition on your education from having been assaulted? Is that really gender-based violence? And Title IX at all. So that's a broad look at the kinds of issues that I see.
Well, and Hanna, in terms of the Dear Colleague letter, one of the issues is the detail in which the Dear Colleague letter described for the universities the procedures they had to follow. And wasn't one of the things that the Dear Colleague letter mandated was that the accused could not question or cross-examine the accuser, thereby depriving the accused of one of the most important tools, if you will, of being able to get to the truth. And is that one of the things that you see these universities doing, is prohibiting the accused from actually engaging in any kind of questioning or cross-examination of the accuser?
That's right, and the advocate can't do that either presently, and that's as I'm sure my colleagues who are actually practicing law on the panel will address later, that's something that is likely to change in the new regulations being promulgated. But yes, that's another example of these tribunals not being particularly truth-seeking and serving the institution, which I think doesn't necessarily reflect evil on the part of the institution. That's the nature of institutions. When they have processes, they're going to protect themselves. That's inherent if you set up this kind of self-policing. But that's the reality that we're looking at, is that we don't get a neutral fact-seeking process. We get an institution protecting process, which might mean sweeping accusations under the rug, or it might mean expelling all the accused students without a lot of inquiry about who belongs expelled. And which way the wind blows will determine what institutions think is in their interest.
Actually,
Well,
I
and
think
Jennifer,
that's
you've written about that as well.
really interesting point, because the goal of a general counsel of a university or an administrator of a university is to protect the university. And so, 30 years ago, sometimes that meant ignoring claims of sexual harassment or sexual assaults because they didn't want bad publicity. And so there were cases, there were cases of sexual assault on many campuses that were ignored and not dealt with appropriately. But really, the same incentives are at work now. They're just pushing in the opposite direction. So now, instead of ignoring the claims of sexual assault, they are trying to convince people not to go to the police, to keep it quiet, to let the school handle it, and to do it in a way that they don't allow the accused person to talk to other students about it, to talk to a faculty advisor about it. So they're completely isolating both the accuser and the accused in an attempt to protect themselves so that the information doesn't get out. And sometimes the allegations are serious allegations that have merit that shouldn't be being handled by, as Hanna said, a math professor. They should be being handled by the police. So it works both ways. There are both frivolous allegations that they shouldn't be coming down hard on, but there are serious accusations that really they should be letting the authorities handle. And I've always argued, okay, so how should colleges do this, right? Let's say somebody is violently sexually assaulted on campus, and they report that to the college police and to the regular police and to college administrators. What should the colleges do while the criminal process is winding its way, the investigation is ongoing? I mean, a college could have a bright line rule that says anybody who's arrested for a crime is suspended until further notice, until that process has resolved itself. Or they could say, any time a claim is being investigated by the police, there's going to be a no contact order where those students can't live in the same dorm, they can't be in the same classes together, right? All of those things are things that colleges weren't doing 30 years ago. So, if somebody brought a claim to the police, they still had to be in class with the person that was being criminally prosecuted for assaulting them. So there are things colleges can do to complement the criminal justice system and to protect students on campus without getting into this, without these kangaroo courts.
Well, and I believe one of the statistics that we often hear is that 1 in 4 women will be sexually assaulted in college. Would you please explain a little bit more about that particular statistic?
Well, obviously that statistic isn't true, because if that statistic were true, campuses would be reacting the way they're reacting to the coronavirus. I mean, they would be shutting things down. And if they weren't shutting things down and sending people home, they would be putting people in single-sex dorms with curfews and not allowing any alcohol on campus. I mean, that's what they would be doing. And frankly, as a parent of 2 college students, I would not send my daughters to college if I believed they had a 1 in 4 chance of being raped. So those statistics are completely false. The Justice Department estimates closer to 1 in 53 college-age women will be sexually assaulted or raped on campus. That's still too much. but it is much less than the statistics bandied about by activists. And the way that they get those statistics is essentially by redefining what sexual assault is. So they're not using the definitions under the criminal law. They're saying, anytime somebody hugs you without your consent, or anytime you have sex while intoxicated, you've been assaulted. And in fact, when they do these surveys, they ask about behaviors, and then the provider of the survey, they decide what behaviors are assault, even when the so-called victims don't consider themselves to have been assaulted. So it's a very misleading statistic.
I appreciate that information. Caleb, I know that you're involved with the Title IX case right now. Could you provide a bit more detail about the case and the work that you're doing for your client?
Sure. And so NCLA, as I mentioned, our interest here is really about the administrative action on the Department of Education. And I don't necessarily disagree with Jennifer about where this is coming from, but I think what we can all agree on is that the Dear Colleague letter had a profound impact on colleges. And a lot of colleges across the country were using certain processes before the Dear Colleague letter, where they would give hearings to the accused students. They would give them the right to cross-examine their witnesses against them. They'd be able to see the evidence against them. And a lot of times they had a standard of proof of clear and convincing evidence, where you had to be proven to have done something wrong to be disciplined. After the Dear Colleague letter, all that changed. A lot of colleges started adopting preponderance of the evidence standards. A lot of colleges actually adopted a presumption of guilt standard. Hearings were done away with. The ability to cross-examine witnesses against you was forbidden. And a lot of times the evidence against you was hidden from the person who's been accused. And so what we have, and in the case that we represent, a professor at Cornell University, he went through a process where there was an accusation made against him. He was never allowed to see the nature of the accusation against him. He was never given a hearing. He was investigated by an investigator who was also the adjudicator. So we have essentially a police officer, or the equivalent, being the judge and the jury and the executioner. And what happened is we represent a professor who was accused by a student who was not succeeding academically in his program. The professor actually had asked the student to leave the program because of academic issues. And then shortly afterward, this professor went up for tenure, and the student said to another professor, "I'm going to make sure that it's very difficult for him to get tenure." And she made a complaint with the Title IX office saying that they had engaged in a secret, illicit sexual relationship for years earlier, and that everyone knew about it, and that it was the Title IX problem. And so what happened is, based on this complaint, our client was asked to defend himself and prove his innocence, but he was never told the specific nature of the complaint. He was just told he had done something wrong with a student. And despite protesting his innocence, and he still does to this day, he was never allowed to see the evidence against him, but he was still required to disprove it. And he still got witnesses. He had students say, "We never saw anything like this. The student has a history of inappropriate behavior and making things up," and all of these sorts of things. And unfortunately, the fix was in from the very beginning, and they found him responsible.
Even to the point where they wouldn't tell him the dates. Explain a little bit about the dates of these alleged events.
Right, and there's one part in the administrative proceeding where he was asked, "You've been generally accused of misconduct. Tell us the dates that this could not have happened." And he tried to come up with dates where he was not in the same state as the complainant, and things like that. And then what happened is, once he gave his evidence of when it could not have happened, the investigators went back to the complainant. She revised her story, and then they said, "Wait a minute, actually it happened on these other dates when you just said it could have happened. So therefore you have You have agreed with us that it could have happened. And I mean, this is, this is what we were talking about with amateurs. I mean, the real problem here is that this is not a process. These are employees of the university who are taking on this function, this adjudicatory function. But I want to step back just even a little bit more. Really what NCLA's interest here goes back to one of the very first things you said, is that Title IX is a very simple statute. It says, it bans discrimination on the basis of sex in education. It doesn't say a college must investigate complaints of sexual assault and deny people the right to cross-examine their accuser and can only use a preponderance of the evidence standard and forbid people from seeing discovery or information against them.
And where'd all that come from?
And that is an invention of the Department of Education. That's right. And that's the real problem. And that's NCLA's problem here, is that we have an administrative agency just sending this letter out to colleges dictating this kind of policy with very serious repercussions for people who've been accused. I mean, our client was fired from his job, and he was a tenure-track professor at Cornell University, and now he is unemployable because of this kind of accusation. And that is our concern.
Well, and I understand that the Department of Education has actually withdrawn the 2011 Dear Colleague letter, but you have sued them in this particular lawsuit as well. Why did you bring a suit against them if they've in fact withdrawn the 2011 Dear Colleague letter?
That's right. And one of the good developments in this administration is Secretary of DeVos has acknowledged some of the problems with the Dear Colleague letter, and she withdrew it. The problem is, once the Dear Colleague letter was sent out in the prior administration, a lot of colleges entered consent decrees with the Department of Education. And because the department threatened to sue them and take away their federal funding. And they said, if you don't follow our rules, we'll take your money away. So they entered agreements where they would change their disciplinary proceedings. They would reduce the burden of proof, all these other things I've talked about. Cornell University is one of them. There are tons of universities across the country. After the Dear Colleague letter was withdrawn, Secretary DeVos still said all of those prior agreements are still in effect. And what we've seen is not only are those colleges that entered consent agreements still abiding by them because they have to, but all the other colleges across the country are still following the old rules that they were forced into. And I think there's a...
But see, I would disagree with the forced into part. They want to have these procedures. And it doesn't really matter what the Department of Education does. They are still going to do this unless people like you sue them.
Well, and you might be right. You might be right about the motivation, but certainly it gave them cover.
Yes, it gave them cover, and it accelerated it, and maybe gave them more specific ways, to implement these policies. But the reality is, this was a grassroots movement by feminists going back to Catherine McKinnon's writings in an attempt to redefine what sexual assault is. And Catherine McKinnon famously wrote something to the effect of, a woman has been raped every time she has sex and regrets it or doesn't feel good about it or something of that nature. And that has essentially become the law on college campuses.
So then there's definitely national politics play a role in this. Would you agree with that?
I mean, yes, politics in terms of, not necessarily elections, but in terms of political movements, yes. I believe so.
And Hanna, in terms of what you've seen, do you agree with that as well?
I do, but it's a fascinating. I'd love to talk to some of my colleagues who study political science, because it is political in the sense of movements. It's not really political in the sense of parties and the usual kind of extreme partisan split that we're having in the country right now. This divides folks philosophically in ways that their party affiliation does not predict at all. And this, I think, this panel is an illustration of that. I mean, I'm on the board at the Chicago chapter of the American Constitution Society. I'm coming at this from a pretty left and self-identified feminist perspective, and I have a lot of critique of this from that angle. Obviously, there's a lot of critics on the right as well, but there are on both the conventional left and right fans, or at least promoters of something like the present system. And so it's been very interesting to see the strange bedfellows that this issue brings up. And in particular, we tend to get lawyers on the critic side, no matter what philosophy within the law they have. Lawyers like process. Lawyers like what we perceive to be truth-seeking process. And that's not happening here. And so lawyers who find out about what's really happening on the ground tend to become critics wherever on the political spectrum they may fall.
Okay. Well, and we've talked a couple of times. I want to make sure that we have plenty of time for people to ask questions as well. And there's been mentioned a couple of times now that there have been some changes made with the Department of Education. And I understand that there are some proposed regulations that have been issued by the Department of Education and Secretary DeVos. Caleb, what is the status of those proposed regulations?
Well, so they've been proposed. There's a notice of proposed rulemaking that came out last year. And we've been waiting for the final regulations. I think you said, we've been hearing for the last 6 months that they're coming out next week. And that's I heard this week they're coming out next week. But they're coming out at some point. And they are, I would say, a modest improvement in the sense that they represent a very clear regulation saying colleges must adopt the following procedures, and they're better procedures than the Dear Colleague letter. They say that colleges are allowed to have cross-examination if they want to. And they're allowed, and they don't have to use certain, they don't have to hide the evidence. They're allowed to give hearings, things like that. And so I think a lot of people see this as a modest victory.
How do you see it?
Well, I see it as even more illegitimate agency action. And I understand that I hate what's going on college campuses, and I don't like what's happened. I don't believe it's fair. And I see that with my own client. It's not fair what's happened to him. But at the same time, this is not the Department of Education's responsibility. This is not they don't have the authority, in my view, to go out and tell colleges the processes that they have to comply with. And it's a simple matter of they don't have any sort of authority to do this in the first place. And one of the legal arguments that we've made in our objections to the proposed rules and in the case against Cornell is that this is a violation of the spending clause. And what I mean by that is, the spending clause, this is the authority that Congress used to pass Title IX, and they said, it's okay for the government to say how we're going to spend our money. And they say to colleges and universities, you can't spend our money and also discriminate on the basis of sex. But that doesn't say, that's not an agreement when Title IX was passed that, oh, and by the way, you have to comply with all these other onerous regulations that we're going to come up with down the line that, in fact, deprive people of civil rights and deprive people of process. And that is not an appropriate use of the spending clause. And so our view is that the regulations are invalid from the very beginning.
Well, and Jennifer, what do you see in terms of changes with the forthcoming regulations that should be issued, again, any day now?
So I think there's going to be massive resistance. There's going to be political resistance. You already see the resistance in the media. Betsy DeVos wants to make it harder for survivors. Betsy DeVos, really, like as if Betsy DeVos wants, rape victims to suffer. Please, she's a mother, she's a grandmother. It's absurd. But that's the mantra that we hear. We're going to continue to hear that. And so there will be resistance on the ground. There are going to be protests. I believe that there's going to be a lawsuit filed to enjoin the regulations, perhaps making some of the arguments that Caleb's just made, that they're beyond the scope of what the Department of Education can do. And then, finally, there's going to be an election in the fall, and if there's a different administration in power, they will, of course, either try to revoke them or ignore them. And colleges themselves will ignore them. There have been several college presidents who have come out and said that they're essentially going to keep doing things the way they've been doing them in order to protect survivors. That's how they couch it. And I think that unless organizations like NCLA sue the universities for violations of due process or breach of contract or Title IX, which are sort of the three categories of claims that they're typically able to make on behalf of people who are mistreated by these tribunals, they're going to continue to utilize these kangaroo courts. And even then, we've seen there have been more than 500 cases, state and federal cases, filed against universities. There have been something like close to 100 court decisions that are favorable to the accused, and there have been many more settlements of cases with accused students. And it's not as if these universities run back and say, well, gee, we just had to pay Jack Montague, the captain of the Yale basketball team, X number of dollars because we mistreated him in this procedure. We better revise our procedures so it doesn't happen again. No, they don't care. They'll just keep paying settlements because really they want to be able to tell the world we're on the side of survivors, and they want to placate the student activists.
Well, Hanna, what do you see universities and colleges doing in response to the new regulations?
And I would just add, and I don't envy the college administrators who are trying to walk this tightrope. I don't think it's an easy thing to run a college in the best of circumstances, and they are getting it from both sides. And I don't think that their struggle to get it right necessarily, again, reflects ill will on their part or disregard for anybody really, but reflects the very strong and expensive pressure that they're getting in conflicting directions at the same time. And that is not an easy thing to balance.
So what is the long-term prognosis here? Jennifer?
Well, it's not good unless parents, students, groups like NCLA continue to fight and advocate and talk about it. And I think the main message that we need to get through to people is that due process is not something that limits justice. Quite the contrary. There can be no justice for survivors without due process. And people need to understand that due process benefits everybody. Because when the procedures are flawed, I believe that it makes people mistrust the system, mistrust the accusations, and therefore actual victims of sexual assaults are not believed because people think, well, this is just one of those kangaroo courts, and this is just one of those rush to judgments that we've seen. And so in the end, it hurts survivors because it takes credibility away from survivors. So people need to realize that this is not an either-or proposition, that a fair process benefits the truth, and the truth benefits everybody.
Thank you, Jennifer. Hanna, what do you see in the long term?
Well, I very much agree with Jennifer's statements just now. And I would add that while certainly I want to see good, fair process and neutral expert adjudicators deal with cases that come up, but I'd like to see a lot more emphasis on prevention. I view both sexual assault and the category that I see very frequently, which I view as terrible negative sexual experiences, which may or may not be assault, but which don't do anybody any favors, can only be prevented with much greater education and support for our young people's developing sexuality. And right now we're miles away from being able even politically to entertain the kind of public health research that could help prevent this problem. And it's not a coincidence that the gold standard study so far for prevention, which is, if anyone wants to look it up, the lead investigator is Sen, S-E-N-N, and it was published in the New England Journal of Medicine, that the lead study came out of Canada, where there are a different set of political pressures on funding for public health research and conduct of public health research. So I'd like to see a lot more emphasis on getting people out of these terrible sexual situations, that whether an individual one is assault or not, people come away feeling terrible. I'd like to see that not happen. It's not good for students. Everybody's education is negatively impacted. It is the modal condition in the cases that I see that no matter who wins the process, and no matter what punishment is or isn't given, typically the students on both sides feel angry at the school, feel that they were not heard, feel that the process was bad, and typically want to leave the school. And they are both then hampered as transfer applicants because their GPAs typically tank during the conduct of this process. So it is just, you really know you've got a bad problem in your adjudication system when the people who nominally win are angry and feel unheard and want to leave the institution. And that's most of the time what I see.
I appreciate that. And Caleb, what about you? What do you see as the long-term situation?
Well, I can't speak to the real sort of underlying problem. And what I can speak to is I think we're seeing movement, and I think the courts are starting to recognize that this solution, and I'm using the scare quotes here, the Dear Colleague letter was not the solution.
Right.
You can't solve a problem like this by depriving people of their constitutional rights and due process. And I'm somewhat optimistic about that part of it because I think I am looking to the courts to help us out of this problem. And I think the courts have been receptive in recent years. They've ruled for a lot of students, and they've recognized that it's not fair what's happening, and it's not appropriate. And obviously what NCLA wants to see is the courts go even farther and say that the Department of Education should not be involved in the first place.
Right.
And it's also about realigning the incentives for colleges, because the more people vindicate their rights and file lawsuits, like NCLA, the more the colleges are going to have to take it seriously. And I understand there's 500 lawsuits or something, but if suddenly it becomes 5,000 lawsuits, right. Then it is something that a college has to consider, and they can't get away with it anymore.
Right.
Education, from that standpoint, is very critical to
Right.
all of this as well, right? And perhaps alumni and other folks weighing in to make sure that it is that we do disincentivize this type of a kangaroo court. Reading the cases, which I've had the opportunity to do in preparing for today, as well as some of the other work that I have done, has been pretty shocking and pretty surprising in terms of what schools are willing to do to address these allegations. And I think all three of you have made very good points at the end of this discussion about why due process is so important. Without due process, it isn't process. It isn't fair under our Constitution. It is not fair under our form of government, and everybody walks away feeling as though they lost the process. They not only lost the process, they ultimately lost the case as well. So I think this is a good time to open the floor up for questions for anyone who may have questions for our panelists. Yes, sir.
What do you do for What do you do for... There, is that better? What do you do for the cases that are not sexual assault but are sexual harassment? And what I'm thinking here are things that wouldn't be touched by the criminal law but might have a very strong campus effect. For instance, just harassments, catcalls, this sort of thing, if it became what we would call in the law, if it became normal on campus. So I understand the sexual assault part of it, but the other part, I guess, is the hostile environment type theory that is often used in courts. What would the campuses do about that?
Right, so I think you raise a really interesting point, because colleges have a right to discipline bad behavior, right? Whatever it is, if it's screaming obscenities in the hallway and violating quiet hours, or as we've talked about, academic infractions, cheating and plagiarism and things of that nature. So they do have a right to discipline bad behavior. I think what makes these cases so extreme is that they've elevated them to a level of discipline that's much higher than any other infraction. So, for example, Caleb talked about the different burdens of proof. They were using a lower standard of proof, the preponderance of the evidence standard, in sexual harassment cases, but still using clear and convincing evidence for graffiti in the hallways, right? So the point is not that colleges shouldn't be able to discipline all forms of bad behavior, but that they should treat all forms of bad behavior the same. And that if you're conducting a hearing to determine whether a student needs to be punished, that student should have the same rights whether or not he desecrated a mural in the museum, or whether he was alleged to have done something sexually inappropriate. The same rules should apply. So they should be able to discipline those things, and it's just how they go about it, which is a problem, and how they go about seeking truth. And in the particular example you gave, let's say catcalls or what have you, if somebody's verbally harassing another student, presumably there are witnesses to that, right? The problem is with these sexual assault cases is they typically occur with two people in a private room under ambiguous circumstances with alcohol. And so actually those should be, if anything, harder to prove, but instead they've made them easier to get convictions on, when there's inevitably going to be less evidence.
Any other questions? Yes, Jessica?
Thank you. When the new regulation comes out next week, what will the effect of that regulation be on the consent agreements that the universities have entered into with the Department of Education? Does the proposed regulation address that, or will it undermine them, or will they continue to operate under the consent agreements?
So they will continue. And the way those agreements work is they've been entered into between the college and the Department of Education. And so one of those parties has to seek some reason out of it. And the department is taking the position, I mean, they have publicly taken the position that no matter what we do rulemaking-wise, they're still in effect. And I don't think any of them are going to go away.
One of the things that happened soon after the Dear Colleague letter was issued was that the Department of Education started evaluating the disciplinary programs that these universities had. And so in the first couple of months, they went and they found that there were 8 universities that were in violation of Title IX. And then within a matter of months, there were 43 universities that were in violation of Title IX. And then it's 96 universities that are in violation of Title IX. And they started publishing a list of all of these various universities that were in violation of Title IX and that they were failing to address and take care of the victims, the accusers, if you will. And so many of these universities, in terms of recruitment and all of those things, as soon as they started getting accused of being violative of Title IX, they were concerned about how it would affect their ability to attract students to come there. It had all kinds of PR implications as well.
It's all about the PR.
And it's all about the PR. And that was one of the reasons why they entered into these consent decrees, because they then used that as an affirmative statement for potential students saying, we are compliant with Title IX. And I think that, Jennifer, in preparing for today, I've read quite a few of your writings in the Wall Street Journal and places like that about this. And one of the things that you've said and you mentioned today is that these universities are not uninterested. They're not like a court. A court is there and looks at both parties as they walk in the room and says, okay, both of you will have certain obligations of what you need to prove. Universities are not disinterested, and the most important thing they're going to do is protect the university, first and foremost, no matter what the allegation is. And that's what you see in so many of these adjudications, is their interest in addressing that PR issue and doing whatever they can to make sure that they are not seen as a bad actor.
In fact, I would tell young people, including my own 2 daughters at college, well, I have 3 daughters, but 2 of them are currently at college, that if you are ever mistreated or raped or assaulted in any way, I would advise them not to go to the university administrators who do not have their interests in mind, and I would encourage them to go to the police. I mean, there may be a reason why you need to go to the university to get a no contact order or what have you, but I wouldn't advocate that they put themselves completely in the hands of the university for resolving the problem, because the university's not on their side. They're not on the victim's side or the accused side. They're on their own side.
Hannah,
Yes,
I think
Karen.
you alluded to this earlier about attorneys tend to see this in a very clear-cut way in terms of deprivation of due process rights, or that there's something inherently problematic with the processes that have been determined. What has been the general consensus from the schools or the administration in terms of answering the due process question? Are they saying that, no, these aren't violative, or what's the general consensus that's come forth on the due process issue?
So you're asking what are the responses of universities when they get sued, or what are they saying in general?
A little bit of both. I mean, I imagine that for the most part, the answer comes through the litigation process, but I imagine it also, there might be other statements to that effect.
Well, I mean, they insist that their processes are fair. They deny that there's a problem. And it's been heartening for me that I have a few colleagues who are Title IX coordinators at universities who are lawyers, which is a good first step. Not every lawyer would be great at this job, but it's a good first step, and who acknowledge that it's really up to the universities to choose to have as fair a process as they want to build. And if they want to have a completely unfair process and just assert that it's fair, I mean, I see that happening all the time. And I serve as an expert witness in a lot of this litigation as to damages. And frequently the universities would say the stakes aren't even that high. So, so we suspended or expelled you. You can go somewhere else. They can't, at least not if they don't want to be dishonest, which I would never advise my clients to be dishonest. So they're going to acknowledge why they were suspended or expelled from those other, from their first university. And they are just clobbered in the transfer process. I mean, to compare, I regularly have students 2 or 3 a year who have felonies, usually resulting from substance abuse, like a DUI felony, for example. Those students are a breeze to place compared to my students who've been disciplined under Title IX. And those are students who typically pled guilty and went to jail. But this is a very, very heavy consequence that ends a lot of education. My usual advice to a Title IX expelled student is I encourage them to apply to about 30 universities as a transfer in hopes of getting admitted to 3 to 5. And as I'm giving that testimony as an expert witness, the universities are saying, no, he can just go somewhere else. This is no big deal. So my feeling is that for the most part, the universities assert and may well believe that these processes are adequate and that they are genuinely truth-seeking.
I think, I do believe that they think their processes are fair, because what they will say is there's no criminal punishment, nobody's losing their liberty here, and we're not finding them guilty of a crime, we're finding them responsible for misconduct. And that's all within the purview of a university to do, as they would do, for example, if, as I said before, if somebody were defacing a painting in the university art gallery, right? But the consequences are severe. And you take the case, I mentioned it before, Jack Montague, who was the captain of the basketball team at Yale University. He was, I believe, the first in his family to go to college, if not the first in his, I believe his mother was an administrator at a school, his father is an electrician from Tennessee. Going to Yale was a big deal for Jack Montague, and the result is that he had to finish at what was essentially a community college back in Tennessee. Don't tell me that didn't change the trajectory of that kid's life. It did. And, that's a case, just like so many of these, where there were a handful of sexual interactions between him and his accuser. Most of them were consensual by her own admission. She says one of them was not. He says he thought it was. And next thing you know, he can't apply to a regular 4-year college and finish his degree the way he could before. So I think it's, and I will say another thing, that with other disciplinary matters that do not involve sexual assault or harassment, there is a willingness on the part of a lot of these colleges to expunge the record when those students come back to them and say, I'm applying to another school, can you help me out? And there's not hard data on this, but I have heard time and time again of students who said, you know what, I know I violated quiet hours, or I know, that there was this incident where I defaced property of the school, but I'm applying to law school now, or I'm trying to get into another college, and could you expunge the record? And they do. They would never do that with these other cases.
Well, and I think one of the primary questions to
And
ask
we don't even need to have those records expunged.
What's that?
My kid who was, if I have a kid who is expelled for selling drugs out of his dorm room, very serious behavior, that kid goes to rehab, he'll get into other schools as a transfer, and he'll get into law school. It's nice to have it expunged, but I can help that kid get, that's Wednesday for me. It's not necessarily that burdensome on getting into another college that you've been disciplined. Being disciplined for Title IX is a whole different story. It makes you radioactive.
Well, and I think probably the proof is in the pudding, just from the standpoint of the universities who have these kangaroo courts and do these kinds of proceedings are not going to be willing to allow a student who has been accused of that in their midst, or a professor. Right. We know from the standpoint of representing professors, it's exactly the same thing. They do definitely have a black mark next to their name, and it's almost impossible for them to move forward in their careers. Yes, Mark?
This question may be for Hanna as well, but anyone can jump in. One of the things that we have seen repeatedly at NCLA, both with cases we have taken and with cases that we have decided not to take or that are still in the pipeline, is that there's often a very long gap between the alleged offense and when the Title IX accusation is lodged or the filing is made. And it frankly seems like something other than the original conduct is what has motivated the Title IX complaint. And Hanna, I just wonder if if you have seen that in your work, and if you have any suggestions on what can be done to prevent Title IX from becoming a weapon that folks are using as a sword rather than using it as a shield to protect themselves when something truly bad has happened.
Boy, I flat out don't know the answer. I mean, I don't know how we keep it from being used as a sword. Because I do see, now I typically see the whole record. I'm not getting just my client's side of the story. I do not see a lot of cases where I read the record and think, she made this up. Like, she is just lying from beginning to end. That's typically not what seems to me the most sensible theory about what happened. But I do see many, many cases where it looks to me like some intervening fact influenced the complainant's interpretation of the disputed encounter. So I see about 2/3 of my cases fit into the broad category of drunken hookup, where the folks are not in a relationship, and typically one or both of them is very intoxicated and they're hooking up. About 1/3 stem from some kind of long-term relationship. And in that second category, the accusation typically follows some kind of volcanic breakup with a lot of teenage drama involved, like the kind of breakup that divides the freshman dorm floor into factions. I see that very commonly. That doesn't mean an assault didn't take place, but it muddies the waters of what is leading to people's interpretation of that night last October when I had X number of beers and we had sex. That actually was rape. And I don't know what we can do about that, except, well, number one, to I'd like to see more empowerment of students to make sexual decisions that they feel good about. Presently, that's not what I see mostly. And also that we have good decision makers who can try and distinguish, try and disentangle all the rage and heartbreak that happens when someone feels hurt, when they feel used. Many of my students, it is beyond dispute that they engaged in jerk behavior. That's, he slept with her roommate, he dumped her by text. There's often absolutely undisputed jerk behavior. And then soon after, or sometimes months or years after, there's an accusation. How do those things interact with one another? I don't know. I mean, I don't necessarily see a good solution for how we can disentangle cases of assault from cases of, emotional trauma in a terrible breakup, or feeling very used and discarded after a hookup.
These cases are so emotionally ambiguous, and that's what makes them different, right? You would never have somebody come forward in their senior year, for example, and say, back when I was a freshman, the guy in the room next door racially harassed me and, put racist messages under my door or made racist comments to me. No, that would be brought up in real time. So you don't have that delay that you have in these cases. And the reason you have the delay is because of the emotional complexity of the relationships. They're not, it's not just, a victim and an assaulter. These are people who were involved with each other. And so that just makes adjudicating it all the more complicated. And I asked a bunch of students, I was teaching a class on this at Boston College Law School, and I started off by asking them, if you were the general counsel of a university, what procedures would you design? Put aside the Dear Colleague letter, put aside, what's out there now. What procedures would you implement to deal with this very real problem on college campuses? And they started off by talking about whether or not there would be a statute of limitations. And one student raised her hand and said there shouldn't be a statute of limitations at all. And I said, so what about after they graduate? And she said, no, a person should be able to come back, bring a claim in a college tribunal, and have a person who graduated from that institution ask for their degree to be revoked. Many, many years later, because sometimes it takes that much time to realize you've been raped. And when that student said that, that's when I realized we are dealing with a much bigger problem than an administrative law problem. We are dealing with a cultural problem.
One of the things that I have been doing
And
is
I'll
looking at how
I'm sorry, that's not hypothetical. I have that case right now. Where the complaint was made after both parties graduated. The university did not did not rescind the degree, but did find the student responsible. The student now 5 years later is applying to law school and has to disclose all of this. So that it's not hypothetical.
So I think you'd be surprised if you haven't spent some time on a college campus how big a role in all of this the campus life bureaucracy plays, right? And so oftentimes they're looking for rumors to turn into complaints, right? And it's so bad that if I were advising a university president, I'd say never hire someone with an EDD from an elite college of education because they're looking for monsters to slay. But everybody knows this, and it's changing the character of research mentorship relationships, and it's changing the character of interpersonal relationships. I mean, I taught political science for 10 years, and most male faculty are always on guard. And I mean, some are very reluctant to take on young female research fellows. And a lot of people won't have a meeting in their office, even with the door open, if there isn't someone on the hall. If it's a female student. So I think that can be part of the conversation. Like, I mean, can that help to sort of raise awareness of the cost of the problem that's going on today?
I mean, I think the college bureaucracy is a huge part of it. I think Harvard has somewhere of upwards of 50 employees just dedicated to Title IX enforcement on campus. I mean,
University of Michigan is the same way. It's absolutely an enormous bureaucracy, and if you don't have the allegations, you have to look at what is the purpose of the office. So definitely it's created some of these problems. And the other thing is that the written rules have changed dramatically over time. So I have been looking at rules starting in the early 2000s up to the current period of time, and watching what was a 3 or 4 page policy that was actually understandable, implementable, something that everybody knew what the rules were. That is no longer what you see on college campuses. They are now 25, 30, 40, 50 pages long, very complicated, very obscure, very difficult to understand, especially for an 18, 19, 20-year-old student to understand how do I comply with this? What are my rights? What are the rules? And then the retroactive application of those very onerous regulations today to conduct and events that might have happened 4 or 5 years ago. And that's something else that's become very complicated that I think that we need to do a better job of educating, because that creates all kinds of due process problems in and of itself. But just watching this evolution and watching how the university rules have changed over 20 years has been very eye-opening to me, to see how that bureaucracy has expanded their authority and their reach throughout every single aspect of college life. I think you make a very, very good point.
and they're not just looking for cases or looking for victims. They are, as Harriet said, drafting policies, overcomplicating things, and then they have a very large role to play in freshman orientations and the culture of a campus generally. They're constantly putting on workshops and training sessions, and rather than using that as an opportunity to teach young people how to protect themselves, they use it as an opportunity to teach young people how to view themselves as victims. For example, I don't believe that any of these colleges tell students as part of these trainings that they should lock their doors. Nobody on campus locks their doors. They believe that there's a 1 in 4 chance of getting raped, and yet they don't lock their door at night. I mean, that is lunacy. And so they're not doing anything to reduce the chance of it happening, and they are creating more opportunities for people to view themselves as victims.
Any other questions? Well, wonderful. Well, I would like to thank our panelists today. Hanna, thank you for being with us. It's wonderful to meet you kind of in person. And I have appreciated the advice and the counsel that you've been providing to me over the last several months. I look forward to staying in touch with you. Jennifer, thank you so much for coming in and bringing your perspective. I have enjoyed listening to you today and learning. And Caleb, thank you, and thank you for what you're doing in attempting to push back against this administrative overreach as you've described it. So thank you.